Gone.
My name is Sidney Kilgore. I'm now in my 37th year as an attorney and counselor at law, and this year marks the 30th anniversary of my membership in the bar of the Supreme Court of the United States. When I became a lawyer, I swore an oath to maintain the respect due the courts of justice and judicial officers. With the advent of the Dobbs versus Jackson decision reversing Roe versus Wade, my faith in the current Supreme Court as an impartial guardian of the rule of law and an institution worthy of respect has been so compromised that I can no longer continue my membership in the bar. In protest of the extreme politicization of the court, I am announcing today my resignation from the High Court, which shall be formally conveyed by letter to the clerk of the court, with copies to the Chief Justice and all 8 justices. Moreover, given the profound disdain in which I now hold the court, I shall be burning my certificate of admission as a symbolic act of public protest. There is no escaping the fact that politics has always had an influence on the Supreme Court and its decisions. Yet the practice of issuing decisions reflecting broad agreement based on a policy of consensual decision-making has all but vanished. As University of Nevada law professor David Orlichter has pointed out, by 2018, it had become the case that one or more justices were dissenting in roughly 60% of all cases. This reflects a lack of ideological balance in the Supreme Court, necessary to produce wise and just results that promote respect for the rule of law. The extreme right polarization of the court, its politicization, was first manifested in the unprecedented Bush versus Gore decision of 2000, when it disenfranchised voters by stopping arbitrarily Florida's count in the presidential election, despite the absence of a substantial question of federal law. The result was to hand the presidency to George W. Bush, a Republican candidate who lost the popular vote nationally and ultimately would have lost to Al Gore had the recount been allowed to proceed under Florida law. The court then bowed to the interests of Republicans and the NRA in the 2008 decision in District of Columbia versus Heller, finding that the Second Amendment to the United States Constitution includes a right to private ownership of firearms that had not been recognized by courts or legal scholars in the prior 219 years of constitutional jurisprudence. The majority opinion was authored by Antonin Scalia, an originalist of convenience, who contorted the law and the English language itself in order to find a right that was never intended by the men who framed and ratified the Constitution based on the historical record. In 2010, the court issued a ruling in Citizens United versus Federal Election Commission, reversing, on First Amendment grounds, a century of campaign financing restrictions and enabling corporations and wealthy donors to commit unlimited funds in elections, if not formally coordinating with the candidate or political party, which the court naively or disingenuously indicated would prevent corruption and would be transparent. Dark money is now political speech, and corporations which are not citizens and have no right to vote have an outsized right to influence our elections. Last Friday, 24 June 2022, the court reversed Roe versus Wade, effectively eliminating a right of women to abortion as a component of reproductive health that had been in place for 50 years. They violated international law, which provides for reproductive health rights, including abortion. The court was not compelled to do this, but was politically motivated. After all, the 5 majority members are Republicans and authoritarian-minded Roman Catholics. Most are reputed members of Opus Dei, which has its roots in Franco's fascist Spain, and Amy Coney Barrett is a member of the ultra-conservative group People of Praise. As the dissent said in that case, today the court discards its balance. It says that from the very moment of fertilization, a woman has no rights to speak of. A state can force her to bring a pregnancy to term even at the steepest personal and familial cost. An abortion restriction, the majority holds, is permissible whenever rational, the lowest level of scrutiny known to the law. And because, as the court has often stated, protecting fetal life is rational, states will feel free to enact all manner of restrictions. Enforcement of all of these draconian restrictions will also be left largely to the state's devices. A state can, of course, impose criminal penalties on abortion providers, including lengthy prison sentences. But some states will not stop here. Perhaps in the wake of today's decision, a state law will criminalize the woman's conduct too, incarcerating or fining her for daring to seek an abortion. And as Texas has recently shown, a state can turn neighbor against neighbor, enlisting fellow citizens in an effort to root out anyone who tries to get an abortion or to assist another in doing so. It's fundamentally unfair when in a judicial system, one political side denies genuine representation to the other political side in a constitutional system based on the principle of liberty and justice for all. Political views are appropriate for the executive and legislative branches of government, but should never be accorded great weight in the judiciary. So as Justice Roberts said in 2018, we do not have an Obama judges or Trump judges, Bush judges or Clinton judges. That's simply not true.